Namens de faculteit Kerkelijk Recht, ik zou hier beter in de microfoon spreken, dus ik begin opnieuw. Namens de faculteit Kerkelijk Recht heet ik u oprecht welkom op deze openbare verdediging. So you're all very welcome at this public defense. Please be all seated. That's a good starting point. And you can take off your hat for those who have one. The others shouldn't do anything. You could maybe, if you are really listening to Father Austin's speech, you could maybe switch off your mobile phones. And let's just explain the procedure to begin this public defense. Father Austin, the candidate, will present a short summary of his doctoral research, as well two additional theses, which you will find in the flyer that you received when you entered this room. And after that, there will be, after the presentation, there will be an intervention first by Professor van der Helm, the promoter, by Dr. Richardson, the co-promoter, every time the candidate answering right away after the asking of the question. Then the other members of the examination commission do intervene. Time and again, the promovendus answers to the question. That's always one of the key elements of this session. Then there is room for questions from the audience. Then we stop the public meeting. Then there is a deliberation that will probably not last till tomorrow morning. And after that, there is then we announce the results. That's how it goes. So let's start now, and Father Austin has the floor to explain what he did the previous years.
Thank you very much. Before starting, I just wanted to thank the faculty and also to thank my parents especially for coming across the Atlantic with me to be here, and also my family who did the same. So also a thank you to Mrs. Elizabeth Dornberger, who hopefully will be able to watch this on the recording. She was, well, without her I would not have been able to finance the studies that I did, so I thank her also. Starting then with the presentation. In 1993, the state of California enacted penal legislation authorizing the prosecution of crimes in cases where the statutes of limitations had already expired. A few years later, in 1998, a California grand jury indicted a man by the name of Marion Reynolds Stogner, charging him with the sexual abuse of a minor between the years 1955 and 1973. The statute of limitation governing the prosecution of such crimes at the time was 3 years. Upon appeal, the Supreme Court of the United States ruled on the 26th of June, 2003, that the California statute in question violated the prohibition against ex post facto laws provided for by the United States Constitution, and as such was, quote, manifestly unjust and oppressive, end quote. On the 7th of November, 2002, Pope John Paul II authorized the Congregation for the Doctrine of the Faith, quote, to derogate from the terms of prescription on a case-by-case basis at the motivated request of individual bishops, end quote. In connection with this authorization, approximately 700 priests and deacons were removed from office between January 2002 and January 2004 in the United States alone. Reflecting upon these extraordinary events, Monsignor Kenneth Bokefola, longtime prelate auditor and former vice dean of the Roman Rota, wrote, quote, the highest United States court in Stogner versus California recognized that it was against natural justice to modify a law for the purpose of punishing persons no longer able to be prosecuted on the basis of the law existing at the time of the delict. One must then ask, If the period a crime might be prosecuted is extended post factum, does this not constitute an unfavorable change of law for the accused? Do not Canon 13:13 and natural justice prohibit such? End quote. Bocafola's provocative and unanswered questions regarding the 2002 Rescript have lost none of their urgency or relevance in the ensuing 15 years. On the contrary, since headlines continue to proclaim new investigations into historical accusations against priests, bishops, cardinals on a nearly daily basis, the urgency and relevance of Bocafola's unanswered questions are increasingly apparent. In this present climate of justicialism, which would always and everywhere intervene despite the passage of time, according to Jobel, this dissertation argues for a restoration of the balance between the interests of victims and the rights of the accused. The central research question motivating this dissertation, therefore, is: to what extent is this power of the Congregation for the Doctrine of the Faith to derogate from the terms of prescription on a case-by-case basis in conformity with the principles of legality and natural justice? That is the essence of the introduction. The three main chapters are on prescription, legality, and natural justice. So we'll give you little précis of those chapters now. Chapter 2 on prescription examines the juridic foundations of the Institute of Extinctive Prescription in the 1983 Code, as well as its raison d'être. The primary conclusions of Chapter 2 are the following. 1. In canon law, prescription is a matter of substantive and not procedural law, unlike some civil systems. 2. There's an objective doubt of law regarding the terminus ad quem of the period of prescription. When is prescription interrupted? 3. After the terminus ad quem has been reached, one truly acquires a right in the sense of Canon 4 not to be accused. 4. The right not to be accused after a determined period of time ultimately is founded on the natural law right of defense. In essence, that's Chapter 2. All right, Chapter 3, legality. The third chapter examines the precise juridic nature of this power contained in the 2002 Rescript and concludes that it is, in fact, a privilege, specifically a power not to observe terms of prescription on a case-by-case basis. Further, due to the ambiguous use in the Rescript of the Italian word termini, it is argued that the privilege must be interpreted strictly. That is to say, it can only be used legally to extend a period of prescription which has not yet been extinguished. The CDF, however, clearly interprets it broadly so as, seemingly, to have the power to resurrect the dead or to revive extinguished criminal actions. The chapter concludes by arguing that this broad interpretive practice violates even that weak principle of legality adopted in the 1983 Code, as well as, a fortiori, the much stronger principle of legality that you find, for example, in the Universal Declaration of Human Rights, the European Convention on Human Rights, the Rome Statute of the International Criminal Court, the Constitution of the United States, and also the law of Vatican City State itself. As it happens in my research, I discovered that there are, in fact, only 3 countries right now, nation-states, that permit retroactive substantive penal laws unfavorable to the accused. Those 3 countries are Bhutan, Brunei, and North Korea. So, Chapter 4 then on justice. So, the principle of legality from chapter 3, although supplying necessary evaluative criteria, is ultimately insufficient in itself. That is to say, quote, the formal regularity that expresses the legality of an act must itself be founded on a deeper principle that justifies it. So the deeper and more difficult question about the Rescript then is not, is this privilege legal, which is important, but also, is it just? In order to answer this more difficult question, chapter 4 presupposes that Cicero was correct when he wrote, there is in fact a true law, right reason, which corresponds to nature, is spread abroad in all human beings, and is unchanging and eternal. That Ulpian was correct when he defined justice as that constant and perpetual will to give to each one his use, his right, or his due. That Vatican II was correct when it continued to require all ecclesiastical faculties of theology, canon law, and philosophy to form students according to, quote, that philosophical patrimony which is perennially valid. Particular consideration being given to the works of St. Thomas Aquinas, who even today is called the Apostle of Truth. Given these fundamental presuppositions, Thomas's treatise on law and the Summa Theologiae is then employed in order to argue that the retroactive application of the 2002 privilege on a case-by-case basis is irrational, unfair, arbitrary, and gravely jeopardizes, or in cases even negates, the right of defense. And as Aquinas taught, quote, if a prescript of law should contain anything contra jus naturale, it is unjust and has no obligatory force, and therefore such prescripts are not to be called laws, but rather corruptions of law. Therefore one must not judge according to them. Before coming to my conclusion, I just want to briefly mention the two additional propositions to be defended, which are closely related to the subject of the dissertation. The first one states that any juridic act placed in virtue of the broad interpretation of the 2002 Rescript is either textually null, invalid, or non-existent. We can get into more details if the committee asks me questions about that. The basic thing there is Canon 124, of course, lays out the two things you need for validity, the things established in the law itself for validity or textual nullity, and then things which essentially constitute the juridic act itself. Of course, the code doesn't tell you what those are. You just have to kind of figure it out. What is essential to something's existence? Well, if it's not there, then it doesn't exist, obviously. Okay. The second proposition to be defended states that the argument that the principle salus animarum suprema lex, the salvation of souls is the supreme law, that somehow justifies a retroactive application of penal norms unfavorable to the accused. That appeal ultimately fails because it considers only the end and not the means. To state this in another way, that argument only considers the extrinsic bonum commune ecclesiae, common good of the church, and not also the intrinsic bonum commune ecclesiae, as these terms are understood in Thomistic philosophy. Finally, then, the fifth chapter of the dissertation is kind of a, well, what are we supposed to do? So if we can't do what the CDF is doing, which is what I'm maintaining, arguing in my dissertation, well, then what can we do? Well, there are actually a lot of things that can be done, in my opinion. For example, how about for those who state that they have been harmed, but now can no longer formally accuse someone in the ecclesiastical forum? Well, as I'm sure you're quite aware, Pope Francis has been quite active in this regard. Just as of 1st of June last year with the Vocestis, the following prescription norm is in place. To ensure that those who state that they have been harmed, note, it doesn't say victim, it doesn't say accuser, it says someone just states that they've been harmed. That's quite a broad category. Anyone who states that they have been harmed, together with their families, okay, a much larger category, are to be treated with dignity and respect, and in particular have the following rights. They're to be welcomed, listened to, supported, including by means of provision of specific services, such as what? The following. Spiritual assistance, all right, and also medical assistance, medical health professionals, including therapeutic and psychological assistance as required by the specific case. Further, even more recently, it was just of 6 December, St. Nicholas last year, now that the pontifical secret has been abrogated in such cases, in particular circumstances, for which we can say thanks be to God, members of the Christian faithful are now both morally as well as canonically free to approach the civil tribunals. Before, that was a bit more complicated, shall we say. Well, what about regarding someone who's suspected or there's an allegation of someone which can't be prosecuted? What are we supposed to do with them? Well, regarding an accused person, or a delated person if you want to be more specific, if an ordinary of the Latin Church should arrive at moral certainty regarding the misconduct of a cleric who is subject to him, without any penal process, he may impose any or all of the following administrative measures. A singular precept, so commanding or forbidding a certain thing, a revocation of his faculty to preach or hear confessions, removal from any ecclesiastical office, official warning, the manitio, a public rebuke, correptio, a penal precept commanding or forbidding something, and if you don't, the penalty attached, of course, and works of public penance, fitting on Ash Wednesday. If a cleric were to become legitimately subject to all of these administrative measures, he would then effectively be perpetually barred from any public exercise of the power of order and all acts of the power of governance. In effect, he would then be maximally subject to the same thing as a grave penalty of perpetual suspension, even though not formally a penalty, but with the same material effects. The only greater penalties he could suffer then would be excommunication and the loss of the clerical state. So that's chapter 5. And then I end the whole dissertation with this quotation, which just appeared maybe a month or two ago, well, a few months ago now. A few months ago, the secretary at the Signatura, Bishop Giuseppe Sciacca, he got kind of upset that these things that no one cared about if they happened to a priest, well, it's starting to happen to some bishops now, and so some bishops are starting to get upset. It's interesting how that works, huh? He said this is quoting Bishop Sciacca. "Punish therefore the guilty, certainly, but always within a system that does not renounce fundamental guarantees, without which a juridic order ceases to be juridic. The presumption of innocence, the right of defense, the non-retroactivity of penal laws unfavorable to the accused, the necessity of arriving at moral certainty before pronouncing sentence, and last, but certainly not least, the institute of prescription, since it is rooted, albeit mediately, in the natural law itself." Thank you.
Thank you very much for this presentation. Now the official procedure is as follows. Professor van der Helm has the floor. I just present him for those who by accident wouldn't know him. Apart from his academic responsibilities at our university, Professor van der Helm is also a priest in a parish of The Hague. He has worked in various tribunals as an ecclesiastical judge, is also an advocate and an assistant judicial vicar in Paramaribo, which is not exactly a full-time job, but it's part of his work. His lectures and research focus on the organization and administration of the Roman Catholic Church, as well as on the renewal brought by Pope Francis. So Professor van der Helm has the floor. He will ask a few questions. The laudatio, the very positive elements, will follow at the end of the session.
Okay. Well, Brian, Father Austin, congratulations with this excellent study that covers not only content of law, but touches upon the principles of law. It's all about justice. Justice for victims of sexual abuse in the church, especially minors and vulnerable persons in the church, but also justice for the accused. And you focused on this last category. Lack of knowledge of law, and specifically of canon law, delivers a community of faithful in the church to an arbitrary way of dealing with cases and situations. It is true that in the aftermath of the tsunami of revealed and alleged cases of sexual abuse, church authorities panicked. We didn't know. We didn't understand, they say. In this panic, some tried to hide as much as possible, or they tried to solve cases to the best of their abilities, sometimes helped by psychologists and psychiatrists who also did not always understand the ultimate consequences of this hideous behavior. Canon lawyers have to consider the proper juridical answer to such a crisis. This dissertation is a critical analysis of this ecclesial response. In your conclusion, and also several moments in your thesis, in your research, you indicated the juridical flaws in the rule of law. As you say on page 75, the Juridic Institute of Criminal Prescription, as in Code 1983 and SST, is incoherent. You are not the only one. You quote rightly Archbishop Scicluna in his 2013 response, who speaks of disregard of the law and demands for justice. And as you say, on page 95, and what is the essence of your thesis, the broad interpretation of the 2002 privilege is against natural law of the right of defense. The strict interpretation is able to be reconciled with the principle of legality and natural justice. It leads me to a general question. I lead to more detailed questions on the more scholarly experts in history and in penal law. But it leads me to a general question, first one. So you are brave enough to defend the rights of the accused. As you say, there's also a right not to be accused. And you reveal the flaws and the dubia in the legislation put forward by Pope Francis, Pope John Paul II and Cardinal Ratzinger. So a more general question is that when I was reading this, were the measures taken in 2002, prepared by other legislation and measures, and also the legislation promulgated subsequently, is this motivated by the panic that broke out, and was it a capitulation for the public opinion that forced the Catholic Church to respond to this crisis? Or was it a serious attempt to use canon law and as an ecclesial instrument in canon law to deal with these cases, to deliver justice? So was it a serious juridical response in spite of the flaws and mistakes, or was it a mere political one? Well, one question. Another question. As you say, and you refer on page 50 to the Roman law sources and Athanasius, who say that prescription is not only related to the difficulty of finding the truth after many years, but also in the fading away of harm and damage caused by a crime. As Roman law and Athanasius say, after the running of 40 years, let it slumber and not be disturbed. But now we have another understanding of the harm caused by these crimes of sexual abuse. Because with the lapse of time, the harm even gets bigger. When people realize after decades what has happened to them, then the harm gets bigger and bigger, and if nothing is done, then people are frustrated, they are damaged, they cannot survive even sometimes. So the question is, does the Institute of Prescription has ever dealt with this problem? Or is this a completely new understanding? And if this is a new understanding of harm and damage, would this not justify the broad interpretation of the 2002 privilege in spite of your conclusion? So should an effective juridical response to this new insight of increased pain and harm after so many years be the response that has to be given in spite of the problems that we see in legality and natural law? Another question, if I may. I refer to Torfs. Well, you quote Professor Torf saying that canon law is protecting the legislator more than the law. Or one could add, more than the vulnerable, be it victims or accused. So is the legislator interested in protecting the victims and the accused, or is it really supporting the executive power in the church? More supporting the power than an instrument of justice. You quote the promoter of justice of the CDF in his justification of the broad interpretation, saying it is for the common good of the church. And that refers also to your second thesis, your proposition. So historically, people could see maybe in the office of bishop the executive of justice inspired by the sacramental presence of the Holy Spirit. Maybe we see this also in the processus brevio where the diocesan bishop has his power to be the judge in clear cases. You state also correctly the failure of many diocesan bishops to observe ecclesiastical laws themselves. So should we not seek for the inspiration of the Holy Spirit somewhere else, in a more independent judiciary power? That's my question, how could an independent judicial power be fit in canon law, where the unity of sacra potestas gives a limited independence or substantial independence? How could this be integrated in penal law? You refer rightly to the criteria of the Human Convention of Human Rights. So how could be a response of penal law? That we were waiting for the renewal of Book 6. Maybe you have some additions to it already. Okay, these are my questions. Thank you.
Thank you very much. I think I'll try to do a both and, so we can see, or more towards them. Okay, well, we'll see. All right, so the first question, if I understand it correctly, is the legislative reforms undertaken in 2001 and then again 2010, as well as in 2002. Was this really a juridic solution, or something more of kind of pandering to popular opinion or a response to the demands? So in the first place, I would want to say that the Sacramentorum Sanctitatis Tutela, promulgated in 2001, I think that was it was almost a moment of juridic clarity, which you hadn't had for quite a long time, really since CS 1962, so the Crimen Sollicitationis. So you didn't really know which crimes were reserved to the CDF, you didn't know what the terms of prescription were, you didn't know a lot of things. So let me just say that right away. I think Sacramentorum Sanctitatis Tutela 2001 was a serious juridic way to address the problems. Having said that, of course, now as we see in hindsight, almost 20 years later, of course, did not address the questions of the bishops, didn't apply to bishops, doesn't address the questions of you know, what we would consider now kind of the secondary or second or third wave scandal of bishops themselves colluding in this or protecting known so-called predator priests doesn't address that level of thing at all. And so even though it's a great reform at the time, it's ecclesia semper reformanda est. The church and the penal law is always in need of being reformed, to be sure. So I think that was a serious thing. In terms of specifically, which I think is more, well, is part of really more your question, well, the topic of my dissertation, do I think this 2002 privilege was a serious juridic instrument or more for popular opinion? I guess I'm getting cynical, but I'm not completely cynical yet, so I want to say that it had a good motive or it's a good heart, let's say, but it has unintended consequences. So yes, it did placate or is trying to placate popular opinion, to be sure, and let's not underestimate the financial interests of the church either that are at stake, right? So, but really more my concern about that 2002 privilege is that it ends up proving too much. It ends up turning over something, what I consider, well, not I alone, but something that's fundamental to the system of law as we have it. So that's my main problem there. If substantive penal laws can be changed and then retroactively applied, well then we're with Bhutan, Brunei, and North Korea, and no one likes those for bedfellows. I don't think that should make you nervous, right? So that's a bit of a, it did too much, or it opens the door to doing too much. That's my main problem there. Well, I have to get to your other three questions, so I'll have to just move along there. In terms of, with modern, the results of psychology and a new understanding of just what is involved with the pain and the terrible tragedy which is the child sexual abuse. So let's just be clear, let's state that right away. This isn't a normal, it's just tragedy, and so there's no question about that. So it's true, absolutely I want to state also that the period of prescription of 5 years, which obtained in the 1983 code for these crimes, was much too short. I don't think you're going to find anyone to disagree with that, so let's be clear with that. I'm also agreeing with that. If there's a 5 or a 7-year-old child who gets abused, no, they're not ready to make a public accusation at 12, as well as also being incompetent in law because they're minors. So yes, they need more time. How much time do they need? I don't know. As Professor Druvet had asked me in an earlier session, you know, well, we need this modern results of health science also to help us. So is this something fundamentally new, the kind of thing that we've never experienced before in like the history of the West? To that I would want to say no. That even in the 1917 code, you know, they had those different categories of delict, right? A notorious, public, delict, and then occult, and then totally occult. And totally occult delicts were dealt with in a quite different way, because by definition, you couldn't prosecute them because they were totally hidden or occult. So the fomes, or the tinders, the smoke of the crime never was revealed. Of course, the classic case is solicitation in the context of the confessional. By nature, it's totally occult. Unus testis, nullus testis, so what are you going to do? This becomes a very difficult thing to deal with. So I would not say that this is something fundamentally never having been encountered in the church. I would not say that. Well, yeah, let's say that. More what I would say, and this is a general comment which I would make it at some point, and I think it still applies to this question too, about the 40 years prescription. Well, if we are encountering a reality that it seems the law at the time was inadequate to address, which we would agree with, I would agree with, 5-year prescription, inadequate, well, then we changed the law, as we did in 2001. So then in 2001, 10 years after the 18th birthday. Okay, so still if it's the 5 or 7-year-old child, let's say, well, now they have until they're 28 years old at that time. You still might say, that's still inadequate. I could easily agree with that. It's still inadequate. So now, of course, 2010, it's 20 years past the 18th birthday, so they have until they're 38 years old.
Is that sufficient? I don't know. It's not my study. I don't know. I don't know if that's a sufficient amount of time for them to come to a place where they can, where they're psychologically capable of bringing in a denunciation to the ecclesiastical authority. I don't know. What I would want to say, though, is this. What I think is really interesting about those are the letters, the exchange of letters between Cardinal Lara and Cardinal Ratzinger in the 80s. I think that really sheds a great insight here, because what that showed was that the great period of antinomianism, or kind of an anti-law spirit that obtained between, let's just say, to pick dates, in 1965, right after the council, even though it started before, and the promulgation of the 83 Code, that time of antinomianism perdured. It lasted, it still lasts today, but the point has been raised many times, and as you, Professor, raised it yourself, the 83 Code has a greatly simplified, already, it's a greatly simplified penal procedure. As Professor Huysmans did tell us in his article, it raised a summary administrative process, which should have been extraordinary. It was extraordinary. It made that an ordinary mode of punishment, very easy to do. You pick up a paper, you write it, almost that same day, you can have imposed the penalty, okay? So you don't have to believe these false tales about, oh, this horribly complicated penal system, you have to be a genius to figure it out. Not really, okay? So that's kind of not true. So the point being, so we have another period of antinomianism, 83 to 2001. So now we have this 2001 document, it's clear. I think we can all say now, 20 years, with hindsight of 20 years, also not applied. Applied in some places, in some places, but generally also ignored. And so there's this, okay, I would just say, if you had to say in one sentence, I would say the solution to a very long period of antinomianism such as that is not another period of antinomianism. So we had antinomianism, the pendulum is over here, we're not applying penal law, and now we're going to have it over here, where we also don't apply penal law, but just in the other direction. And kind of those two wrongs will find the middle way. I think that's a grave mistake. Obviously, that's what I argue in my dissertation. Okay, so I have 2 questions left and 6 minutes, so let's see what we can do here. Well, I'm just going by my, so.
It's okay?
Oh, I still have, no, do you want me to do the other 2?
No, Professor van der Helm is entirely satisfied. Yeah.
Okay.
So thank you. Then we come to the co-promoter, Father William Richardson, who is a priest of the Archdiocese of Dublin. He holds higher degrees in classics from the University of Dublin and in canon law from St. Paul University and University of Ottawa, as well as the doctorate in canon law from our university. He currently is the promoter of justice for the diocese, for the Dublin Metropolitan Tribunal, and the deputy judicial vicar for the Dublin Regional Marriage Tribunal. He has lectured at the Faculty of Canon Law here for the last 8 years. He will now ask also a few questions. Dear colleague, you have the floor.
Well, it's good to see the conclusion of the work, because the number of emails that came on a regular basis required a lot of work on my part, but it was always an interesting thing to open your emails. As regards your work, I think the strengths of it are particularly in the fact that you have this historical perspective in regard to canon law, a perspective which isn't always apparent in many modern works in canon law. Many people do not go really much beyond the 83 Code. They may go look at the 17 Code, but they certainly don't look very much behind the 17 Code. The strength of your work is that you place the prescription in its full historical context, not only within canon law, but also within the classical tradition and also the current civil traditions. So also you have the benefit of many languages, which is extremely important to gather everything together. and expose, certainly to the English-speaking world, many things which are not readily available nowadays. So I think from that point of view, it is an excellent work, and I also think it would be deserving of publication after this defence succeeds, which we hope it will. Now, in regard to the questions, I have two, and the first question refers to, there was a meeting last Friday of the Pontifical Council for Legislative Texts in Rome, and the Holy Father addressed it. And the reason he addressed it was because he reported that the Book 6, the revised Book 6, has now come to its conclusion. But he said he's not going to tell us when it's going to be published, so we don't know when it's going to become the law. But I quote something from his speech, which I think is important. He says, "Avoiding arbitrary solutions, the law becomes a valid bulwark in defence of the least and the poor, a protective shield for those who risk falling victim to the powerful. Today, in the context of a world war being fought in pieces, one can see how a lack of law and a lack of rights go together. Dictatorships are born and grow without laws. This cannot be allowed to happen to the Church." So my question is, since there is still a little bit of time before the publication of the new book, if you were asked to give advice, what would it be? And the second question relates to your second proposition of the two, in regard to the Salus Animarum Suprema Lex. The title of your thesis talks about ad normam juris aut ad nutum legislatoris. Is it the norm of law or the pleasure of the legislator? Is this final canon of the Code, 1752, Salus Animarum Suprema Lex, is that used ad normam juris, or does it actually bolster the nutum legislatoris?
Thank you, both very interesting questions. So in terms of what would I recommend? Well, I should check my email, but probably I didn't receive any request from the Holy Father to advise him, but so we'll just for academic purposes, of course. So that's really chapter 5, of course, is what can be done or what should be done, in my opinion. And so just not to give you the whole précis, I suppose, but we'll think in terms of what can be done for potential victims and what about the accused. For the potential victims, those who state that they've been harmed, again, I had quite a large section about 2 years ago, and then as Pope Francis did several things, several of the sections went away, and so I started being a bit desperate, thinking, I hope I have something for this chapter 5 by the time I get to defend the thesis. But that was specifically the pontifical secret, which is mostly abrogated now. It still pertains, but to the for graver delicts, of course, child sex abuse, of course, would be one of them. That pontifical secret doesn't oblige. I think that's a great thing, that it's been repealed, so that's already been done. Also, too, this kind of way of accompaniment that Pope Francis is very good on, very strong on, I think that's very much something that has been absolutely neglected when people come forward with complaints. I have no problem admitting that. And again, with Vos Estis, just last June, he at least said to local churches, well, you have to provide for this. How they will go about providing for that, even on the economic level, is something that's not yet been addressed. We haven't tried it out yet. It just started in June, so I don't know where these free tribunals exist or free mental health professionals exist, but that will be an interesting challenge to try to rise to. Those were my main things for the accused, so far as I recall. In terms of reforms for potential victims, sorry. So in terms of things to recommend in general for those who are accused, of course your own work, the presumption of innocence, about the presumption of innocence, which turns out that really effectively there is not a presumption of innocence. That we would say very much has to be put back into the fore. And then I think we could very well use as a model these different documents from the European Court on Human Rights. to see how it is that the presumption of innocence is defined there, and then concretely, not just a nice vague abstraction, but concretely, what does that look like? One thing, for sure, would be to secure the right to a judicial penal process. I completely agree with Monsignor Huysmans that, well, if you can disagree, but as far as I remember, that this administrative way of punishing, even though it's a so-called administrative penal process, it does not have the guarantees that we would consider normal in a civilized society where the rule of law is present. They're very much jeopardized by that brief, summary administrative penal process. I think if someone wants one, they should have a right to a judicial penal trial for sure. Also, as it says in the the European Court of Human Rights, also has that right to a true second grade of jurisdiction, which the fact that that's been removed from the signatura, as you know, these cases are only for the congregation, the doctrine of the faith. If you want to appeal, the judges all stand up and move over one chair and sit down, and that's your second grade. I'm exaggerating just a little bit, not very much, but that's your second grade of jurisdiction. So if you consider that a true appeal, well, good for you. I have some bridges I have for sale for you in San Francisco. But at any rate, if we could restore the second grade to the signatura, I think that would be wonderful. I was very dismayed to find that Montini, who had been the promoter of, the secretary there, that he had written some very strong articles kind of on this theme, and then he was very unceremoniously dismissed. They didn't even mention him in the press relief from the Holy See. It just renamed his successor. So that's very Italian. That's very nice. Goodbye. So that's very sad that you have very senior members of the highest court in the church treated in such a very poor way. That is a very bad sign. So that would need to be restored. Okay, the second question, I could say a lot more than that, but people are getting nervous already. So, okay. So the second question then, the final canon of the 1983 code, of course, famously, is a procedure for the transfer or dismissal of parish priests, and then famously is the little tack on at the end. Of course, in this whole procedure, and then kind of the scope gets very wide, we should remember that the salus animarum suprema lex, that the salvation of souls is the supreme law in the church. You can kind of hear the orchestra playing in the background, dun, da, 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 and it's kind of nice or whatever. I don't think it's well, I'll just say this. It's not very juridic. It's not a very juridic thing to say. I agree with Father Richardson. It's not that principle. Okay, let me say a little bit more about that. So that principle is really a principle of, it's a principle of theology and also moral theology, but then what is this appeal about? So if you think about, again, using the categories given to us by Aristotle and Thomas Aquinas, for a society, a true society, it's proper to speak of a true society having a common end which is indivisible, but still communicable to each individual member of the society without any diminution. Okay, so think of the baptized in the church. We can all be members of the church, but just because I'm a member of the church doesn't take away any part of your being a member of the church. Okay, so what is the common good of the church? Well, we can think of this in many different ways. St. Thomas gives you many different ways to think of it. To break it down simply, we can think of and this is the second proposition, the external public good of the church, or the external common good of the church, is the final end. It's that for the sake of which the society or community exists. So, what's the end? What's the final end of the church? It's, of course, it's the bride of Christ. It's for the sake of the salvation of souls. And what's that for? Well, ultimately, of course, that salvation of men and women is for the sake of contemplation of God for eternity. So, of course, God is the final end, the final object of the church, of course. Having said that, since that's the extrinsic common good of the church, we should notice immediately that it actually completely, well, it transcends juridic categories. Huh? No one has a legal title or a right to eternal life. If we could, then we'd be back in the Old Testament, where a bad understanding, where you could work out your salvation by your own merits, and you could merit salvation. Here's my title to eternal salvation. It doesn't quite work that way. So that expression, the salvation of souls, is the supreme law of the church. It's really not a juridical formulation at all. So when people, if you notice, not just, you don't have to pick random examples, we can pick actual examples. So when men like the secretary, or sorry, the prefect of, former prefect of the Congregation for the Doctrine of the Faith, no, Scicluna, he had two different titles. He was secretary, thank you. He was secretary of the CDF, and he said, well, you know, we don't like using this 2002 privilege retroactively, but you know, there's the salvation of souls to consider. And it's a very common argument you hear, but then, as you see, it's just kind of hand-waving in the direction of a principle. But if you look, and they don't actually elaborate, how is this, what does that mean? How is it, why is this, how does the salvation of souls, how does that justify this, disregard for law and disregard of the principle of legality? So it's not a very juridic thing to say, I would say. So that would be my main way to answer the...
Does it bolster, sorry. The real question in that was, does it bolster the rule of law, or does it bolster the pleasure of the bishop?
Yes, okay, thank you for reminding me. Well then, just to be clear, that kind of argument definitely gives way to the antinomian spirit, so it doesn't bolster the rule of law at all, but it gives way to this rule by the will of the superior, and they can just say, well, since I have the good of souls at stake, I'm going to choose to do this thing. Well, that's why God gave us laws, so we can follow them rather than just complete arbitrary administration. Sorry.
So, thank you very much. Now we come to the next stage of this defense. We turn to the other members of the examination committee, and it is an established tradition at our university to invite also external examiners as members of the jury. And I hope it works. Apparently it does. And I'm very pleased to give the floor to Professor Valère Nkouya-Mbanji. I first present him briefly. He is a Jesuit priest. He is a professor of canon law at St. Paul University in Canada. His field of research focuses on the protection of minors and vulnerable persons in canon law, and he's particularly interested in the interaction between canon penal law and the various secular, between brackets, criminal systems. He is the author of a book called La prescription canonique des délits sexuels sur des personnes mineures, published by Édition Artege Le Thielleux in Paris in 2018. Dear colleague, you are somewhere above me like some other Jesuits. We are most grateful that you accepted our invitation to join the examination committee, and I am pleased to give you the floor.
Thank you very much. Good morning to all of you. Thank you, Mrs. President. Hello, Father Austin. How are you doing?
Very well, thank you, Father.
I don't know if I'm allowed to have a conversation with the candidate. Is it possible? Is it allowed?
What was your question, Father? Sorry?
I was just asking if I can have a kind of conversation with the candidate. I would prefer just to ask a question and then have an answer and continue. Is it possible?
Yes.
Thank you. Thank you very much. I will first say that this is an excellent dissertation. I was really pleased to go through your dissertation, and thank you for the hard work that you did. It's really wonderful, and I think that you should publish it maybe before they change the book 6. I don't know. Would that be possible? We don't know when. I don't know. But thank you for what you have done. And also, I would like to underline the fact that you have many languages. That is really helpful for your work. You were able to read to read from different sources. I think that's something great. I have really liked, in particular, the chapter 2 on prescription. My first question will just be, what is the connection between prescription and equity when you consider both the accused and the victims? Should I repeat? Which connection will you make between prescription and equity?
Equity, yes, thank you. So I think this is the question. What connection will you make between prescription and canonical equity, considering both the victim and the offender? Is that right?
Yeah, thank you.
Okay, great. Okay. Would you like me to answer that one first and then go to your second question?
Please, yeah.
Okay. So I'll look this way since that's where the camera is, and then I have a little picture of you here, so that's how that works. Okay, we'll try this here. So what connection between prescription and equity? I'm glad someone asked that because I did a lot of work on that, so good. So I would say that so I hope we all should know what prescription is, well, at least the students here. So prescription, a means of acquiring or losing rights or being freed from an obligation due to the passage of a period of time, all right? And then equity. Now, so equity would be, if we use Thomas Aquinas's definition, equity is a relaxation of the rigor of the law, where a judge would set aside the letter of the law in a particular case so as to better arrive at a just solution of the case. So he sets aside the letter in order to achieve the spirit. That is St. Thomas's definition of equity. So several things we'll note about canonical equity. In that sense, equity is a remedy, it's a true legal remedy, but it's to be exercised by the judge. That's the first thing. It pertains to the judge to exercise canonical equity. It does not really pertain to the legislator. It's not the right place for equity. If the legislator sees a number of cases where the law is no longer effective or no longer admits of a just application or solution, the responsibility of the legislator is to change the law. That's just a basic principle of law. So equity is for the judge. That would be point one. Point two about equity also is canonical equity has always to be understood as an application of mercy. It's not an application in favor of more rigor. So for example, if a judge has a case, and let's say we've done a judicial penal process for the sake of the argument, like a unicorn, maybe you've never seen one, but you've read about them in books, right? So let's say you have a judicial penal process, and the judge determines that the accused is guilty. He may increase the punishment that the law establishes. Why? Because of equity? No. Because the law grants the judge that ability in certain cases and circumstances to either increase or decrease the punishment established by law within a certain measure. If a judge should decide to increase the penalty, it's not an exercise of equity. It's in fact the opposite. Equity has always to be interpreted in terms of a more favorable solution for the accused, not a harsher one. So that's what I would say about equity and prescription.
Thank you. I would like to continue in the same. I would just like to share a kind of made-up case. Just imagine Father Austin, that Father called Joshua, has abused more than 15 boys' school, for example. Can you hear me? Hello?
Yes, I can hear you.
Yeah. Just imagine that Father called Joshua has abused maybe 14 boys' school, and the last victim that he abused was in 1980. If you are a judge now, if you are a judge in front of this case, what will you do?
Good. So just make sure the audience can hear their question, or so I make sure I'm understanding it. So we have a case of let's say a cleric for the sake of the argument who has abused 15 minors. So he had a very bad problem, but then stopped in 1980. And now it comes before a judge in the year 2020. So 40 years have passed, which would be beyond the period of prescription. If I'm the judge, what do I do? Is that what you're asking?
Exactly.
Okay, good. Well,
what can you do?
Good. Good. Well, first I'll tell you what St. Thomas says you should do, and then that will give me time while I'm telling you that to think about what I would do. Okay? So what? Okay. So what St. Thomas says is that the judge in such a case, equity would allow the judge to act praeter use or praeter legem, beyond or aside or apart from the law. The judge can do that, but the specific thing a judge can never do, because it's a vice, the judge cannot choose of his own volition to act contra legem. The definition of that vice is called usurpation. It's a usurpation of authority. I am a judge. I have judicial power. I do not have legislative power. Only the legislator can set aside a law. You cannot act contra legem. There would be a sin for St. Thomas, okay? So, what would I do? Well, I hope I wouldn't commit the sin, okay? So the judge would have to remit the case. The judge doesn't have standing in the case, because standing in a case is given from the existence of a criminal action which has been destroyed. So someone in the CDF says, well, even though this criminal action is destroyed, you as a judge have the power to prosecute it. I disagree, which is why I don't work at the CDF, that and other reasons, okay? So I would never be a judge there. If I were a judge there, I would have to resign my office, which they would make them happy, and it would make me even more happy. So that would be but that's not really your question, I think. I think what you're really asking then is, if I am the bishop, and I have such a case in my diocese. This doesn't even address the cases. How does one come to know with moral certainty all of these things are true, which you've said?
Please, Father Austin.
Yeah.
Please, Father Austin. But, okay, good. If you are a judge, you will act like that. But now, if you are working at the CDF and you have received the privilege to derogate from prescription, what will you do?
I would resign.
Perfect. Now I would like to go to my second question. My second question, how could we conceive the right of defense of the accused in case the legislator returned to the imprescriptibility?
Yes, so I think I have the question here. How does one then conceive of the right of defense of the accused in case the legislator should return in the future to a system of criminal imprescriptibility? Okay.
Yeah.
Yes. Well, that's a very good question. As is well known, before in the 17 Code, and then in the Secrete Contenere, which was before that, there were crimes reserved to the Holy Office, now the CDF, which had no period of prescription. So how can the right of defense be exercised in those cases? So as you'll see, I'm pretty careful to note in the dissertation that it's not in an absolute sense that prescription negates the right of defense. If we were to return to such a system, then I think we would also have to, since that endangers the right of defense for sure, then we would have also then to make other additional positive due process considerations that would favor the accused. For example, if we were to return to that system, I would think for the sake of justice, we would also have to return then to the system of an absolute right to a judicial penal process and an absolute right to a true second grade of jurisdiction, to the signatura. Those would be the two minimum things that come to mind to help to ensure the right of defense. I'm just thinking of the case of Cardinal Pell, which is pending even as we speak, where one of the witnesses, there were two witnesses supposedly, and one of whom has since, well, he retracted and then died, and so that makes it very difficult to get him to say anything. And the other one, I don't remember what's happening to the other person, but we have this here. So what are you going to have? You have the one witness. So then we might consider also, in these cases, will we let one witness have full proof? Does that have full corroborative value, the testimony of one witness after 40 years? You say it's 15. Well, again, we don't have a way to prove that unless we have a judicial trial. So at any rate, that would be the beginning of my response.
Yeah. Okay, thank you for that. Now, my last question, you have it already. I would like to know more about the intrinsic bonum commune ecclesiae. Do you have it? Yeah.
Yes. So
what do you intend?
So Father wants to know, he's asking, what is this intrinsic common good of the church that you're speaking of in that second proposition, the intrinsic common good? So the intrinsic common good is, you could think of as the means, but it's the very mode of living itself of the community. So in the church, of course, we have the Greek word koinonia, or in Latin, communio.
Yeah.
That would be the intrinsic common good of the church. It's precisely how, that is, we don't just desire the salvation of souls, right? That's the extrinsic common good. We do desire that, but we desire to achieve that common good communally, precisely as church, as a community. So that's still kind of abstract, you might say. So more concretely, what specifically is meant by the intrinsic common good of the church? Fundamentally, that would be the revealed word of God, the word and sacrament. Those would be the shared common, those are intrinsic common goods of the church, which are apportionable, but non-divisible, and they belong to all the baptized by right. They have a title, their baptism is their title. They have a right to the word and the sacraments, and it's also common goods which do not suffer diminution in the sharing. And so it's in precisely that common shared mode of those things, that will be the intrinsic common good, that for the sake of which those goods exist, is the salvation of all men and women.
Yeah. And the salvation of all men and women, that's great, thank you. Shall we say maybe more practically the salvation of all the abuse, all the victims of sexual abuse? If we said that it's also the salvation of all the victims of sexual abuse, can we say that because we know that today many people in the church, they are asking for justice? I don't know if you have heard the case going on now in Paris with the Cardinal Barbarin. So we have a lot of Christian faithful who would like to receive justice because they have been victims, they have been abused. How can we put together this bonum commune ecclesiae and the desire of the Christian faithful to have a church, like Pope Francis will say, who cares not about the institution, but about the faithful? What will you say?
I'm not sure I understand the question, but I'll try this and see if this is the question. Are you saying these people who have been sexually abused, how are they to achieve salvation?
My question is, those who have been sexually abused, can we understand today the common good, the bonum commune ecclesia of the church, without taking into consideration their own voice because they are crying for justice. It's also linked to the institution of prescription.
I'm sorry, Father, I don't understand the question. So.
Okay.
I'm sorry.
How can we consider the bonum commun, the intrinsic bonum commune ecclesiae, with the will of the community, the Christian faithful?
Yeah, it's maybe difficult to understand the question materially, so maybe we best conclude this session with warm thanks to Professor Nkuyam Banji.
Okay.
Thanks a lot
Thank you very much
for joining us.
Thank you. Thank you.
And then we come to the next person, and that's Professor Ruud Huismans. He's a priest of the Diocese of Rotterdam. He obtained the degree of Doctor Utriusque Juris in Rome in 1966 and graduated as a lawyer at Roman Rota afterwards. From 67 to 96, he was professor of canon law at university, the Catholic Theological University of Amsterdam, and later also of the Catholic Theological University in Utrecht, both in the Netherlands. After that, he became, so from 1966 onwards, he became a professor of penal and process law, and also of many other topics at our faculty here in Leuven, where he is in theory now emeritus, yet in practice that is hardly visible. We're always tremendously happy when he's with us, and it's a pleasure to give him the floor.
Thank you very much. You got the paper. Turn to the bottom of the first page. You have the text as well, some of you. The third page after. The dissertation intends to argue and argues with the risk of qui nimis probat nicel probat. The broad interpretation of the Rescript is contrary to the principle of legality and to natural justice, and the strict one can be reconciled with both of them. I go to the bottom. Is the dissertation clear and without hesitation arguing the broad is unacceptable and the strict acceptable? Okay. Turn the page. There are two reasons for this question. I compared this text, the text of today, with your previous pre-defense text. On page 196, I find, which I did not find in the first draft, extending a period of prescription, which is still running, also increases criminal liability. If a penalty is subsequently imposed in virtue of this increased liability, then one could argue that a heavier penalty has been imposed than that which was applicable at the time of the offense, and that the violation of Article 11 of the Universal Declaration of Human Rights has occurred. Neither the broad nor the strict interpretation seems fair in this regard. That's the first reason for my question. Are you convincing? This, the book. Second, new with regard to the concept, I go to the fourth line. The strict interpretation, although not irrational, nevertheless retroactively increases criminal liability on a case-by-case basis, which is unfair and arbitrary. Moreover, the indefinite extension of the terms ad quem of a currently running period of prescription would also gravely jeopardize the right of defense, as well undermine juridic certainty. The strict interpretation, although admitting of just application, is also open to abuse and unjust application. I quoted two parts of your words. Are you convinced the broad one unacceptable and the strict one unacceptable and the strict one acceptable or not? Or are you hesitating? Because that's the main thing of your dissertation. The broad one not, the strict one could. Then my second question, I go page 2. The right of defense, question chapter 4, belongs to natural law. Okay? When denied, the process suffers from the nullity established by the natural law itself. According to your dissertation, the effect of a violation of natural law is the nullity of the act. This, according to me, is exceptional. Normally, in other cases, violations of natural law, which is not a written law, it is not a kind of secret book, natural law, which God had and church magisterium can explain. It is a principle or something like that. So normally, violations of natural law are considered heavily immoral or illicit, leaving it to human positive law or to justice, human justice, to declare it invalid or null. Validity or invalidity of an act is more a category of human law than of divine or natural law. If this is true, what's the practical significance of this nullity established by natural law if the right of defense is denied? And a small one, then I go to the previous paragraph. You wrote on pages 92 till 95 and 90 and 150 in the middle of the page that the CDF maintains the application of this broad interpretation. If the broad one, by denying the defense, is illegal, unjust, etc., contrary to natural law, what does this mean for the validity of the practice of the CDF? You don't give an answer to this question in the book. You can do it now.
Good. All right, let me just see if I have this first one.
First, if you are convinced, or the book is convincing others.
Yeah.
So I want to say that I'm very convinced about the broad interpretation being acceptable, absolutely without qualification, both in terms of legality and natural justice. On the strict interpretation, I don't think I was hesitating, but I can't, it has to be qualified. I have to qualify it. I can't say unqualifiedly yes or no, because...
You say yes.
Well,
except for the parts
for legality,
I quoted.
Right. So the strict interpretation, pardon? So the broad interpretation, extending the terminus ad quem sometime in the future.
Till you die.
Right. So if we receive the institute of the privilege, as is in the 83 code, if we're going to, so since it's there, I guess we have to, whether we like it or not. So since it's there, I didn't find anything in the code or the tradition that is, the legislator has the power to revoke acquired rights. So if you haven't acquired the right yet, you haven't reached the terminus ad quem, he can move it only by the institute of the privilege legally. That's what I was trying to argue. That's for the that's the strict interpretation. So he can do that without revoking any acquired right. And also, since he used the institute of the privilege, he doesn't, technically speaking, change any material, substantive penal law. Now, I don't like that, but you know, my will doesn't make the law either. I do argue in the dissertation, I don't think the Christian faithful should be allowed to be punished in virtue of a privilege. I think that's very wrong. But this is, we see how it's legal in the very strict understanding. The legislator has that ability in the code.
But even if it is a privilege, a special one, then I come to my second question. Again, can this be against the right of defense and against?
Right, so that's the thing.
And the natural law, the law of
right, so I would, again, I have to say qualified because sometimes it would be and sometimes it wouldn't, so not absolutely. So for example, right now, as of 2010, the law is 20 years past the 18th birthday. All right. So let us also say that we don't really know when prescription is interrupted, let's just say for the sake of the argument. Because if we knew that, then as soon as the person was cited with a libellus, the prescription would be interrupted. But we don't know that, I argue. But maybe we do know it. Maybe someone knows it. That single rodal judge knows it, so I guess that's enough. Okay. But let's say the citation hasn't come yet, and that period, the person's 37, and it's a few weeks away. Okay. Let's just for the sake of this argument and say, well, the judge hasn't given the accused hasn't been cited yet. So the criminal action, which is available to the litigant, is in danger of being extinguished. You could apply for this broad strict, you could apply for the broad interpretation of the privilege, and I would argue that that's not a substantive, you're not taking away, this is not unjust if you give the person another year or 2 years or 3 years to prosecute the case, even though, no, it should have been extinguished after 38. Okay, well, it'll be 38 in 2 months. So in that case, it wouldn't be. However, I thought I argued in the dissertation that if you were, on the other hand, to say, oh, this action is in danger of being extinguished, and let's say you're the bishop, and let's say you're a bad bishop, and you say, oh, I have a credible accusation, I have a really good witness, and she has really good proofs, this action's about to be extinguished, you know what? Rather than seeing justice done, I'm just going to hold on to that card for a little while. And now I have a great weapon against this priest when I want him to do something that I want. So I'm going to say, yeah, let's go ahead and move that terminus ad quem, and I'm going to move it to be 40 years from now. So I own you for the next 40 years. So that, I mean, it's a bit rhetorical, but, you know, we have cases of blackmail in this way. So then that's why I'm saying it's open. Even the strict interpretation is open to a use such as that, which obviously I would...
Right.
Yes, so I'm opposed to that.
If you have money, go to Rome, try to open the doors of the CDF and to look in their jurisprudence, which is not published, only few things, and then you can see if they accept the broad interpretation or not.
Right, so they do. So
but if so, they are against God. Natural law.
I agree. So thank you for saying that for two things, because I meant to say it, and for God, one of the things I definitely want to say in this reform of penal law, yes, please, can we have at least redacted jurisprudence of the CDF published? I see no way how this offends against justice or anything, given the embargo period. That would be for sure. Well, the thing, so even though they broke, there are many dioceses that have done this, but the Archdiocese of Milwaukee, which I cite in a footnote, the Archdiocese of Milwaukee put all of the cases on the website that have all of the correspondence from the CDF, and so you have literally dozens and dozens, unfortunately, cases where you can read them, and you see that, in fact, the CDF is interpreting it broadly, and they continue to do so. So that is, in fact, the case.
Explain to the public what the CDF means.
Yes, the Congregation for the Doctrine of the Faith, formerly known as the Holy Office and formerly known as the Holy and Universal Roman Inquisition, which maybe not so holy, or at any rate.
Okay.
Thank you.
Thank you for ending up with the Inquisition. So the last person of the jury I can give the floor today is Professor Wouter Druet. I first situate him also. He's an assistant professor of Roman law and legal history at KU Leuven, Faculty of Law. His research mainly concerns the legal history of the Low Countries, the early modern jus commune, and the history of canon law. Recent publications include 2 monographs, Loans and Credit in Concilia and Decisiones in the Low Countries, around 1500 till 1680, and another book is Scandalum in the early Bolognese decretistic and in papal decretals, between 1140 till 1234. And sorry for my hesitation in reading this text. That's of course not acceptable. More important is that I can, with a lot of pleasure, give the floor to Professor Druet.
Thank you very much. Thank you also for inviting me to this doctoral committee, to this examination committee. I will first start with a short evaluation and then ask a few questions. First of all, let me say that the dissertation concerns a highly relevant theme. The regulations regarding statutes of limitation and prescription are under constant discussion these days, both in canon law but also in civil law jurisdictions. One can refer, for instance, to the very recent abrogation in November 2019 of prescription for grave sexual crimes against minors in Belgian civil law. The thesis is very well written and well documented. It was a pleasure to read the text, so congratulations. You develop clear research questions and sub-questions. You guide the reader through the answers in a very structured analysis. You use a great variety of scholarly texts and sources in many academic languages, let me stress that, including English, of course, but also French, German, Italian, Spanish, and Latin. So congratulations for that as well. Especially in the first 4 chapters, you develop a convincing reasoning based on a thorough canonical analysis and an interesting evaluation on the basis of some basic moral theological tenets regarding natural law by St. Thomas Aquinas. And of course, as a Roman lawyer and legal historian, I also liked your attention for the jus commune literature, which is too often neglected in current-day canonical research. So congratulations as well. But as it is the duty of the Board of Examiners to also give criticisms, I should mention that I'm somewhat less convinced by your 5th and final chapter. In that chapter, you provide the reader with some recommendations and conclusions. But in my opinion, in this final chapter, you somewhat lost track of your main research objectives. Prescription and statutes of limitations become only a minor issue in that final chapter. In fact, it's a survey of a lot of other possible measures that the Church could take in lieu of the 2002 Rescript. But given the large number of legal issues tackled in this final chapter, it has regrettably become a somewhat less developed part. Each of the recommendations could in fact have justified a dissertation on its own. As that was evidently not feasible, you often limited yourself to a far less detailed analysis. Thus, frequent reference is made to the practice of the European Court of Human Rights, but unfortunately, you only focus on a very limited amount of sources which, in effect, have no legal value as such, as you base yourself on some of the summaries provided by the court itself, not on a critical analysis of the court's decisions itself, and that's a little bit regrettable. It's especially unfortunate that you did not go into the European Court of Human Rights case law under reasonable time, mentioned in Article 6 ECHR, so that would be possible recommendations for future work of yours. A question then, but it's a long one. I will limit myself to one question, but it's a long one. In your thesis on pages 49 till 65, you discuss the rationale for prescription of actions, and you list 7 principal reasons for prescription. Playing the devil's advocate, I could argue that none of those reasons really necessitates a regulation or regulation concerning prescription. The first reason concerns the avoidance of scandal, but the non-punishment of grave sexual crimes, even after a very long time, sometimes also induces scandal. The mentioned reasons of expiation and presumption of emendation due to the long period between the criminal behavior and the trial could be taken into consideration at the time of imposing the criminal penalties, as the European Court of Human Rights sometimes suggests in its case law on reasonable time, but should not necessarily impede the trial itself. The idea that the long inaction of victims leads to a presumption of tacit condonation is highly problematic in light of recent psychological studies which stress the many burdens a victim has to overcome in order to be able to denounce the alleged offender. Prescription as sanction for a lack of vigilance by the promoter of justice might be too harsh a sanction, definitely, as it is often impossible for the promoter of justice to know of the criminal behavior before the actual complaint or denunciation. Juridic certainty is not a very convincing argument either, especially the Roman law foundation, the so-called lex criminales causas mentioned on page 61 of your dissertation, is weak, given that the Roman law of extinctive prescription in criminal cases only focused on the period from the litis contestatio onwards, meaning from the moment the trial was pending. Finally, the protection of the right of defense is, of course, a highly important value. I fully agree. But does it really require any system of prescription, of fixed terms? To what extent is such a regulation of prescription for the right of defense really necessary? Could one not adopt a case-by-case approach? Of course, always by stressing the presumption of innocence and the need for moral certainty of the judge. That means the exclusion of any prudent doubt of making an error in law or in fact. That means also that if the judge would consider it impossible in a certain case for the defendant to offer proof against some of the witnesses, that he could take that into consideration in not reaching moral certainty. What would you answer to that? Thank you very much.
Thank you, Professor. Could you just repeat the question again at the very end?
So the very question is, do we really need a system of prescription? As 6 of the 7 principal reasons for prescription are not really that strong in order to impose a system of prescription. And as the 7th reason, which is of course a very important reason, could perhaps also be taken into account in another way, by a case-by-case approach, focusing on moral certainty and the presumption of innocence.
That's a very large question, of course, so I feel myself inadequate to answer it, but I have to think about something to say. So, the first thing I would say is the idea of the law, of course, well, one idea of the law is to attempt to give an abstract statement of general cases, right? So you can't possibly legislate for every individual case. So you try to give some general principle. That's one of my worries about the 2002 privilege, specifically because there's no ratio normae given at all for its use. And so that I think it speaks to your question, because part of my worry about the 2002 privilege.
If I may just intervene, I fully agree on your analysis of the 2002 Rescript, because that concerns the going against an acquired right. But I'm looking to the future, a general system of imprescriptibility in the future.
Right, so imprescriptibility in the future, okay, but so still the case-by-case thing would be worrying to me. So, because that, by definition, you need to have discretion in the law, but then this seems to me to open the door to not just discretion of the judge, but arbitrary punishment. So why would one person's case is held to be not able to be prosecuted, but this other person's is. Well, that's why we have prescription, I guess. This would be one thing. That's one reason for prescription, is that you have that juridic certainty. Well, you said you don't think it's a sufficient reason. Well, it's not the only reason. Again, I would say. I found, as I went back in the history, I have not done the extensive research on this. You mentioned Article 6 on not useful time, but available time. Reasonable time, thank you. You mentioned Article 6 on reasonable time. As you correctly say, I've not had time to research that further. It would be very interesting to look at that. I would be very interested in that. One thing I might say was, when I read through all the different controversies about the Institute of Prescription in canon law, there was this vacillation between a time where time was held to be accounted not continuously according to continuous time, but according to useful time. So you had something like that. So if you had a completely occult, a completely hidden delict, which no one ever found out about until 40, 50 years later, finally the person is able to come and say, this happened to me. In the old system, that would have been the useful time would only begin to run when it becomes known to the judge or the prosecutor. So that also existed in canon law before. So it could be something where some cases could go back to that. My worry with that, as I read through that way of handling it, was precisely then who makes the distinction? What are the juridic facts that we can ascertain in the public forum that help one to know when is a delict completely occult, when is it simply occult, when is it public, when is it notorious, those 4 grades they had. And then is this something that is practicable is another thing, that how do we decide, well, this person was ready to come but didn't come, or to me, I don't know. It seems very difficult to ascertain then when the useful time begins to run or not. So I don't know if you could have other ways of doing it. Is prescription absolutely needed? Well, we didn't have it for certain crimes, so it seems that it's not in the church tradition. It's not absolutely needed. I have to agree with that in that sense.
Okay.
Well, thank you very much for all the questions and all the answers. But apart from the jury, there is also the audience with a right to speak, and the audience, that's all of you. Is there anyone who has questions with regard to the doctoral thesis as such, or the 2 additional theses that are that can be written on the sheet of paper that you received at the entrance? It's now or never.
Yeah.
No candidates? If not, then the jury will retire for deliberation, so we suspend the meeting, but be sure, at some stage we will come back.
So I'm giving my lecture, she's giving a talk. Okay, thank you. Thanks for your God, thank you.
So please be all seated. That's the best way to listen carefully to a very short announcement, because after deliberation, the jury came to the conclusion that Mr. Brian Thomas Austin obtained the degree of Doctor in Canon Law. We have no tradition, well, it's forbidden even to give grades, magna cum laude and those things, but it's with a lot of pleasure that we grant him the degree of Doctor in Canon Law. Warmest congratulations.
Well, Dr. Austin, congratulations with your title. We were very pleased as the jury to read and study your dissertation. You are a specialist in what is a privilege. So when you receive a privilege and you want to be sure what is the value of this privilege, then you call Dr. Austin until you know what it is worth about. I think it's your dissertation that is, as we said earlier, Dr. Richardson said it, is really worthwhile to publish it. I think it's a very big need for it to be published, and we'll discuss the details, but it would be very good if this will be published. It will be support of penal law, a support of wisdom that you have gathered. So we are always also happy with this result of this research that you have done. You go into history, you go into secular law, into human rights law, and I think it's a contribution to canon law to consider herself her own wisdom. So thank you for that. It was a pleasure to work with you. As a promoter, I learned a lot from you, because the specialist in penal law and history is Dr. Richardson, of course, and I was also very happy when I received your emails, and because you have access to a lot of sources. So thank you for that as well. So it was a pleasure working with you. Now, and that's what you are can also be an example for other students, for other possible doctoral students to pursue the studies in canon law, because there is this wisdom that you can discover. Of course, all the specific details about prescription, about terminus ad quo, terminus ad quem, and what the consequences for justice are immensely important. So as I said before, this is about justice. And we have always, as canon lawyers, to consider that our job, our work, our research is for justice in the church, to defend the vulnerable persons, be it victims, be it the accused, because there are very important principles that have to be protected. So as a promoter, I said it was an honor to work with you. And as we as a jury and we as faculty are very happy with this result, and it will be inspiring for you yourself, for canon law, and also for other students. Thank you, congratulations, and God bless you. You want to have the final word?
Have the final word.
As a doctor.
As a doctor. The first words as a doctor.
Licentia ubique terrarum docendi.
Well, thank you very much. Thank you to the faculty, the committee, particularly, of course, my promoter and co-promoter. They both mentioned the volume of emails. Well, I think they've created maybe a spam filter for me, you know, this goes to later. No, I do send quite a lot of things, and I know that they did read them, and that's quite a thing. So thank you both very much for that. And also to the rest of the faculty members too, for their received very extensive reports and criticisms on the first draft, and I wasn't able to implement everything, but it's not published yet, so God willing I'll be able to perhaps do more of that. So also to the support staff and the rest of the academic staff, your thanks as well. So thank you very much. And thank you to Father for getting up at 6 in the morning or 5 in the morning in Ottawa. Thank you.
It was a pleasure. Thank you.
session is over. Thank you very much for your presence over here.